Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review.
It's me. Hi, I'm Liz Montano, it's me, here with my esteemed colleague and friend, Ed Ramos, to cover the podcast this week while our fearless leader, Kevin Gregg, is away. As Kevin knows all too well, the courts tend to go a bit crazy when he's not around. But you're all safe and sound because Ed and I have dropped everything now to make sure you all get your weekly pod fix. We have 7 cases for you this week, 2 of which were actually published late Friday, June 23rd, after Kevin had already taken off. Literally, he was on a plane. And one of which is a 7th Circuit case that got a bit lost in translation over the last few weeks, but don't worry, we didn't forget that it existed. The remaining 4 cases were published this week. Ed will start first by covering the 3 cases not published this week, and then I'll come back and tag team with Ed for the remaining 4 cases. Now, are you ready for it?
Our first case is United States v. Hansen, issued by the Supreme Court on June 23rd. This is a criminal case about 8 U.S.C. 1324 A1A4, which punishes the encouraging or inducing of certain acts involving illegal immigration. And the question before the Supreme Court is whether the statute is facially overbroad because it sweeps in too much speech protected by the First Amendment. To be clear, the facts here were not a good look for the defendant, Mr. Hansen. Mr. Hansen had lured hundreds of immigrants to come and stay unlawfully in the U.S. with false promises of getting them citizenship, including through adult adoption, which is just not a thing. Mr. Hansen had ensnared nearly 500 non-citizens, ripping them off to the tune of about $2 million. But the question before the Supreme Court didn't turn on the facts of Mr. Hansen's case. That's because Mr. Hansen had brought a facial challenge to the statute, arguing that it swept in so much speech protected by the First Amendment that the whole statute should be invalidated. And the argument was about the meaning of the words encouraging and inducing, and whether those words were so expansive that they would capture things like an op-ed or a public speech criticizing the immigration system, supporting the rights of non-citizens to remain in the United States, or similar types of speech, so long as the author or the speaker recklessly disregarded whether the readers or listeners were undocumented. The Supreme Court rejected that argument, holding that the words encouraging and inducing were meant to refer to criminal solicitation and criminal facilitation, terms of art that have a much narrower meaning than the broad definitions that Mr. Hansen was pushing. Solicitation refers to the intentional encouragement of an unlawful act, and facilitation is assisting a wrongdoer with the intent to further the offense. And both solicitation and facilitation involve a mens rea element, requiring that the perpetrator knowingly intend to perpetrate something that's unlawful. Now, to reach that conclusion, the majority noted that the words encouraging and inducing historically have been used to refer to these narrower criminal offenses. The Supreme Court majority also noted that the statutory context supports their interpretation. So construed, the majority held that the statute is not so overbroad as to fail a facial challenge, because it penalizes far more unprotected speech than protected speech. Quote, "To the extent that Clause 4 reaches any speech, it stretches no further than speech integral to unlawful conduct. Speech intended to bring about a particular unlawful act has no social value, therefore it is unprotected." End quote. At the end of the day, the Supreme Court saved the criminal statute from total invalidation by reading it narrowly. The statute survives, as does Mr. Hansen's criminal conviction. One final point of interest for immigration lawyers. Mr. Hansen raised an interesting overbreadth argument. He pointed out that many immigration law violations are civil in nature, not criminal, and argued that Congress can't impose criminal penalties on speech that solicits or facilitates a civil violation. A similar point was also raised in an amicus brief filed by a whole host of immigrants' rights organizations, who warned that in part because of this civil-criminal mismatch, the statute, quote, criminalizes enormous amounts of accurate, competent, ethical legal advice by attorneys. Scary stuff. The majority essentially sidestepped the issue, though, saying that even if that theory were right, the ratio of protected speech to unprotected speech was not so lopsided that a facial challenge should succeed. The majority also pointed out in a footnote that its decision left open the possibility of an as-applied challenge if a criminal defendant wants to argue that their specific conduct was protected by the First Amendment. No real guidance, though, from the court to immigration lawyers on how the statute would apply to legal advice to non-citizens who are in violation of civil immigration law, or advice that would incidentally require non-citizens to remain in violation of immigration law. And that was United States v. Hansen. Next up is Flores v. Garland, issued by the Fifth Circuit on June 23rd. This is a short case on I-140 petitions and the national interest waiver. The EB-2A employment-based preference category makes visas available for non-citizens who have advanced degrees or exceptional ability, but it generally requires a labor certification. Under the INA, however, USCIS, quote, may waive, end quote, the requirement when USCIS, quote, deems it to be in the national interest, end quote. This is often called the national interest waiver. The statute doesn't put forth any specific test, but the AAO, the Administrative Appeals Office, has done so in a precedential decision called Matter of Dhanasar, which sets forth a three-part test plus the final exercise of discretion. In 2019, David Flores filed an I-140 petition, arguing that he merited a national interest waiver. USCIS denied the national interest waiver and thus the I-140 petition. He sued in federal district court to challenge the denial, which dismissed the lawsuit for lack of jurisdiction. And the Fifth Circuit affirmed. In short, the Fifth Circuit joined several other courts in holding that USCIS's denial of a national interest waiver is a discretionary decision over which there is no judicial review under INA 242 A2B2. That statute bars review of decisions specified by statute to be in the government's discretion. And the Fifth Circuit pointed to two aspects of the statute that compelled that conclusion, according to the Fifth Circuit. The first is the word may, which the Fifth Circuit notes connotes discretion. And the second is the word deems, that USCIS deems it to be in the national interest. Again, the Fifth Circuit found that that signaled, as a statutory matter, a conferral of discretion on the government. The Fifth Circuit also rejected Mr. Flores' counterarguments. First, Mr. Flores argued that to truly be unreviewable under the statute itself must use the word discretion. But the Fifth Circuit found that couldn't be right, because Congress, in other contexts, has specified discretion using the word may without using the word discretion itself. Mr. Flores also argued that because national interest waiver decisions are bundled up with the I-140 adjudications process, and I-140 decisions are generally non-discretionary and reviewable in federal court, that means that national interest waiver denials must also be reviewable. The court didn't buy it, basically saying that reviewability of the I-140 petition just depends on why it was denied. Where a denial follows directly from the denial of a national interest waiver, the I-140 as a whole will be unreviewable. Where the basis, however, for an I-140 denial is not tethered to a national interest waiver denial, but rather just the criteria for the particular preference category, those decisions will remain reviewable and can be challenged in federal district court. Finally, for the Fifth Circuit, the fact that U.S.C. itself set forth a standard for national interest waiver adjudications doesn't impact the jurisdictional bar on judicial review, because the statute specifies national interest waiver denials to be in the discretion of the government. Either regulatory or precedential decisions fleshing that out doesn't create a basis for judicial review and doesn't circumvent the statutory bar on judicial review. The bottom line is that there is no jurisdiction to review national interest waiver denials in the Fifth Circuit, and so the district court was right to dismiss Mr. Flores' lawsuit. And that was Flores v. Garland. Next is Qui v. Garland, issued by the Seventh Circuit on June 16th. This case is about adverse credibility decisions. Ms. Qui is a Chinese national who sought asylum based on forced abortion and sterilization by the Chinese government. This is one of those rare contexts where the basis for asylum is quite clear. By statute, quote, a person who has been forced to abort a pregnancy or to undergo involuntary sterilization shall be deemed to have been persecuted on account of political opinion, end quote. That's at INA 101A42B. Here, Ms. Qui testified that she had been forced to abort pregnancies and had been threatened with involuntary sterilization, which, if true, would make for a pretty clear-cut asylum claim. The problem was that the IJ and the BIA had made an adverse credibility finding, which the Seventh Circuit ultimately affirmed. There were a couple of inconsistencies that the Seventh Circuit highlighted. Ms. Qui testified that after she arrived in the U.S., she resided in Chicago, but when asked by the IJ, she couldn't provide her address, and the IJ ultimately found that she had never lived there. Ms. Qui also had several convictions for unlicensed massage work, but she denied any culpability despite the criminal convictions in the record. She also testified inconsistently about when she first applied for a visitor's visa, and there were also some inconsistencies regarding the name of the hospital where she was allegedly forced to have the abortion. The Seventh Circuit was less concerned with the last discrepancy cited by the IJ, Ms. Qui's mention of a forced IUD placement that wasn't in her affidavit. Quote, this type of minor discrepancy between an applicant's pre-testimony written statement and more detailed testimony given at a live hearing might not support an adverse credibility determination, end quote. For the Seventh Circuit, though, there were just too many material inconsistencies and instances of evasive or untruthful testimony for Ms. Qui to win in federal court on the highly deferential substantial evidence standard. So Ms. Qui lost her case. And that was Qui v. Garland.
This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey and don't want to listen to just me, ask your colleagues, or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. This podcast is also sponsored by Capital Good Fund. Millions of families seeking to improve their immigration status face financial barriers due to the high cost of legal services. Nonprofit Capital Good Fund is working to make these resources available to all, especially those who would otherwise not qualify for traditional loans. Certified CDFI Capital Good Fund is partnering with attorneys to provide the financial services families need. They offer affordable financing with no closing fee or down payments for those working with attorneys to move their case forward and get attorneys out of the accounts receivable business. To learn more about the program, email immigration@goodfund.us or call 866-584-3651. And tell them who sent you.
All right, let's get into the cases published this week. First up is Brizuela v. Garland, published by the 8th Circuit on June 27th, 2023. This is a case, at least in my brain, that makes sense to separate into two parts, as there are two distinct legal arguments and sets of relevant facts for each. First is the due process argument of it all, and second are the relief claims of it all. I'll address these in that order. So first, the due process of it all. Ms. Brizuela and her children are citizens of Honduras who entered the United States on November 8, 2017, and were speedily issued NTAs charging them as inadmissible under INA Section 212A 7A II for not possessing valid entry documents at the time of application for admission. 3 days later, on November 11, 2017, Ms. Brizuela and her children were extended humanitarian parole for 1 year until November 8, 2018. The dates are important, I promise. So Ms. Brizuela's removal proceedings, proceeded, and she applied for asylum, withholding of removal, and protection under CAT. At her master calendar hearing, she conceded the charges in the NTA. However, at her individual hearing on September 11, 2018, 1 month before her parole was set to end, Ms. Brizuela argued that her proceedings should be terminated because she was not removable, seeing as she had parole until November 10, 2018. Instead of terminating the proceedings, the IJ decided to continue the proceedings so DHS could have, quote, a chance to address the issue, end quote. Though the IJ did recognize that the matter would become moot on November 10, 2018, when Ms. Brizuela's humanitarian parole ended. But the IJ reset the merits hearing anyway for December 14, 2018. And at that hearing, Ms. Brizuela conceded that her humanitarian parole had then expired and that she was removable. Ms. Brizuela asserted on appeal to the BIA that the IJ had violated her due process rights by continuing her case instead of terminating it. The BIA rejected the claim, concluding that Ms. Brizuela's removability at the time of the hearing was uncontested and that she, quote, had not established how her proceedings would have been different if her case had been terminated, end quote. Which is a bit of a funny way of phrasing that, because if her case had been terminated, there would be no proceedings at all, which is quite different than being in proceedings, but I digress. In her petition for review, Ms. Brizuela argued that the BIA's 2015 opinion in matter of U.S.C., quote, obviated a petitioner's need to demonstrate prejudice to sustain a due process claim in the immigration context, end quote. But the 8th Circuit reminded us all that in that circuit, a non-citizen's, quote, due process claim must demonstrate both a fundamental procedural error and prejudice, end quote. The 8th Circuit then agreed with the 4th Circuit, the 3rd Circuit, and the 11th Circuit that matter of U.S.C., quote, did not abolish the requisite showing of prejudice in the context of due process claims, end quote. Ms. Brizuela then argued that by continuing her proceedings instead of terminating them, the IJ, quote, was engineering a preferred outcome, end quote. But the 8th Circuit again disagreed, stating that the IJ merely had not researched the issue before and, quote, simply wanted to give DHS a chance to address the issue, end quote. But in any event, the 8th Circuit still requires a showing of prejudice, and unfortunately for Ms. Brizuela, the court did not find such a showing here. Instead, the court stated that the continuance gave Ms. Brizuela, quote, exactly what she was promised, presence in the United States until November 10th, 2018, end quote. The Eighth Circuit concluded that Ms. Brizuela's due process rights were not violated. Now, on to the relief claims of it all, which, of course, we need a bit of background as to why Ms. Brizuela and her children fled Honduras to understand. Back in 2013, Ms. Brizuela's partner, named Darwin, was murdered by MS-13, quote, gangsters for a reason unknown to Ms. Brizuela. Her partner's mother reported the murder to law enforcement, who ultimately arrested at least one of the gangsters, but not the actual murderer. Then, throughout the 4-year period between 2013 and 2017, Ms. Brizuela received threats over the phone and saw the gangsters in public, but they never actually carried out their threats. The threats subsided for a period of time, but began again in 2017 when the gangsters began calling Ms. Brizuela's place of work, pretending to be clients, describing her clothes, and warning her to be careful. That was when she fled to the United States with her children, fearing that the threats had turned more serious, detailed, and frequent. While the IJ acknowledged that Ms. Brizuela had suffered psychological harm as a result of the threats, the IJ concluded that the threats did not rise to the level of persecution needed for asylum and withholding, and found that her objective fear of persecution was undercut by the fact that her partner's mother still lived in the same area of Honduras and remained unharmed. The IJ also denied protection under CAT. The BIA affirmed on all accounts, recognizing that Ms. Brizuela had suffered psychological harm, but stating that, quote, although psychological harm is sufficient and harm need not be permanent or serious to establish persecution, it still must result from an extreme level of conduct, end quote. In her petition for review, Ms. Brizuela asserted that by requiring petitioners to not only demonstrate that they suffered harm, but also that such harm resulted from extreme conduct, the BIA created a, quote, radical new legal theory never previously announced or applied, end quote. But that was not so, said the Eighth Circuit. Citing its 2017 decision in Lima Sarita v. Sessions, the Eighth Circuit explained that asylum and withholding of removal is available, quote, only to those who have suffered from persecutory conduct, end quote. And while psychological harm, quote, may substantiate an allegation of persecutory conduct or evince its degree, end quote, such harm alone is not enough without a showing of actual persecutory conduct itself. The Eighth Circuit then concluded that substantial evidence supported the BIA's decision that the gangsters' threats to Ms. Brizuela did not qualify as such persecutory conduct. This was because, quote, the threats were telephonic, sporadic, and over a period of 4 years, end quote, and because there was no evidence that the gangsters acted or even attempted to act upon the threats over the 4-year period, quote, the threats lacked immediacy and appeared exaggerated, end quote. So, while the Eighth Circuit did recognize that some of the threats to Brizuela were specific and that they did cause her psychological harm, none were, quote, so menacing such that this case belongs to the small category of cases in which threats alone constitute persecution, end quote. In making that conclusion, the Eighth Circuit harked back to its 2020 decision in Cano v. Barr, in which the court found that a mother's, quote, experience of being threatened at gunpoint while helplessly watching her son be beaten and abducted, end quote, was not persecutory conduct because she, quote, experienced only an unfulfilled threat of physical injury, end quote. Because that case involved more direct and more menacing threats than those suffered by Ms. Brizuela, and they still did not meet the required level of persecutory conduct, the Eighth Circuit affirmed the BIA's decision that Ms. Brizuela had not suffered past persecution. As to Ms. Brizuela's well-founded fear of future persecution, the Eighth Circuit rejected that argument as well, quickly stating that Ms. Brizuela had specifically tied that argument to a favorable finding of her past persecution. In other words, if the Eighth Circuit remanded as to her past persecution, it would necessarily have to remand as to her well-founded fear of future persecution as well. But unfortunately, the Eighth Circuit did not remand as to Ms. Brizuela's past persecution, and, at least according to the Eighth Circuit, Ms. Brizuela made no other arguments as to her well-founded fear of future persecution. As a result, the Eighth Circuit denied Ms. Brizuela's petition for review. One more quick note. At the end of its discussion of Ms. Brizuela's due process claim, the Eighth Circuit acknowledged that she spent, quote, a substantial portion of her briefing contending that the BIA did not alternatively address whether the IJ abused its discretion by continuing her case without good cause, end quote, as required by 8 C.F.R. Section 1003.29. But the Eighth Circuit rejected this argument because Ms. Brizuela had allegedly failed to raise this issue as an independent claim before the BIA and instead had only raised it as, quote, a means of establishing the fundamental procedural error, prong 1, of her due process claim, end quote. So because the Eighth Circuit believed that Ms. Brizuela had failed to exhaust her administrative remedies as to this independent claim, it declined to review it for the first time in her petition for review. And while the Eighth Circuit did acknowledge the Supreme Court's decision in Santos Sicaria v. Garland, discussed on episode 159 of the pod, that said exhaustion of administrative remedies in immigration proceedings is not jurisdictional, the Eighth Circuit still found that such exhaustion was appropriate here, where a petitioner, quote, does not dispute that she was represented or that the proceedings were adversarial, end quote. So just another reminder to preserve your arguments in the record. And that was Brizuela v. Garland.
Next is Din v. Garland, issued by the Second Circuit on June 30th. This is a case about frivolous asylum applications. The INA imposes stiff penalties on non-citizens for filing a frivolous asylum application. In this context, frivolous really means fraudulent. The penalty for filing one has been described as the immigration death penalty. It's essentially an unwaivable and permanent bar on nearly all immigration benefits. This case involves two brothers, Saeed Kaleem and Saeed Arsalan Din, who are natives of Pakistan. They entered the U.S. on visitor's visas, overstayed, and were put into removal proceedings. With the help of an attorney, they filed asylum applications in 2008 based on a fear of the Mutahida Qawmi movement, or MQM, which, according to their asylum applications, had arrested and tortured them, among other things. On the I-589 applications, each signed the warning advising them of the consequences of filing a frivolous asylum application. Before the IJ could rule, the Dins got married to U.S. citizens, and they filed I-130 petitions and got them approved. They then switched lawyers, and the new lawyer filed adjustment of status applications in immigration court based on their approved I-130 petitions. The new lawyer asked the IJ to terminate proceedings so that the adjustment applications could be adjudicated by USCIS. DHS, however, opposed termination, raising questions about the asylum applications. The new attorney then submitted a letter from the Dins saying that the story about the MQM's persecution had been made up by their prior lawyer. The letter explained that their prior lawyer had simply told them to sign the asylum application and would, quote, take care of everything, end quote. DHS countered with a letter from the prior lawyer stating that, basically, the Dins had lied and that he had, in fact, reviewed the contents of the asylum applications with them. By 2018, the Dins had withdrawn their asylum applications and were only pursuing adjustment of status in immigration court. DHS acknowledged that the Dins were prima facie eligible for adjustment, but opposed it on account of the fraudulent asylum applications. The IJ ultimately denied the adjustment applications. The IJ found the Dins statutorily ineligible because they had filed frivolous asylum applications. Remember, a frivolous asylum application filing bars nearly all immigration relief, including adjustment of status. But to really drive in the knife, the IJ also denied adjustment in the exercise of discretion, stating that the fraud that they had perpetrated on the immigration court outweighed their positive equities. The BIA affirmed, and everything went up to the Second Circuit on appeal. Before the Second Circuit, the Dins raised several challenges, but only one of them was successful. The opinion discusses that one last, but I'm going to lead with it. The argument was a technical challenge to the frivolousness finding. the DINs essentially argued that they never received proper notice of the consequences of filing a frivolous asylum application. See, for the frivolousness finding to take effect, the statute requires that the non-citizen be given notice of the consequences. That's why the I-589 includes that long warning at the end. In the DIN's case, the IJ and the BIA believed that the DIN's signature on the I-589 was enough evidence that they had received the required notice. In support, they cited a Second Circuit case, Niang v. Holder, which the government argued set forth a standard under which the applicant's signature constitutes, quote, dispositive, end quote, evidence of notice. But the Second Circuit disagreed. It held that a signature gives rise to a presumption of notice. But a presumption can be rebutted, and here there was conflicting evidence, the DIN's statement and the testimony that they gave in immigration court that their prior attorney never explained the consequences of a frivolous asylum application. The Second Circuit remanded for the IJ and the BIA to make the necessary fact-finding to determine whether or not the presumption of notice was rebutted in the DIN's case. Okay, so now for the bad news, the arguments that the DINs lost. The first was another technical attack on the frivolousness finding. The DINs had actually filed their asylum applications after the one-year deadline, and a regulation implementing the frivolousness bar, 8 C.F.R. 1208.20, requires that a material element of the asylum claim be fraudulent. The DINs argued that no part of their asylum claim could be material because their applications themselves were untimely and therefore unapprovable. It's a creative argument, and in fact, that's the law in the Third Circuit. But most other circuits to consider the question have held otherwise, and the Second Circuit joined them in this case. The court reasoned that the one-year bar is not jurisdictional, and that there is no statutory or regulatory requirement that IJs consider the one-year bar issue before a frivolousness finding. The court thus held that the asylum application can be frivolous, even if it's untimely. The Second Circuit also rejected the DIN's arguments challenging the denial of their adjustment of status applications. Remember, the IJ had denied the DIN's adjustment applications on two separate grounds. First, for being statutorily barred because of the frivolousness finding, and second, in the exercise of discretion. And the Second Circuit had ruled in the DIN's favor, at least on that procedural issue involving notice of the frivolousness finding consequences. But to keep their adjustment application alive, the DINs also needed to overcome the second basis for the denial, the discretionary finding that they didn't merit adjustment in an exercise of discretion. But the Second Circuit refused to disturb the IJ and the BIA's alternative basis for denying adjustment. The DIN's first argument was that after the IJ made a frivolousness finding, there was no longer any authority to deny the adjustment application in the exercise of discretion. Essentially, the DINs argued that once the frivolousness finding was entered, the IJ had to stop there and couldn't reach the issue of discretion. But the Second Circuit rejected that argument because the frivolousness bar is not jurisdictional, and also because the regulations and BIA precedent allow the IJ to enter orders on alternative theories. The DINs also challenged the discretionary denial on the theory that it was so intimately intertwined with the frivolousness finding that a reversal of the frivolousness finding also compelled a reversal of the discretionary denial. But the Second Circuit found that argument jurisdictionally barred under INA 242 A2B1 and Patel. At base, the IJ denied adjustment based on the factual finding that the DINs had knowingly submitted materially false asylum claims. Under Patel, there's no jurisdiction in federal court to review any factual issues pertaining to an adjustment of status application. And for the Second Circuit, that made it an open and shut case on jurisdiction. To be sure, the Second Circuit had overturned the frivolousness finding on a legal ground, whether the DINs had notice of the consequences of filing a frivolous asylum application. But that in no way impacted the IJ's factual finding that they had knowingly submitted false information with their asylum applications, and whether they were aware of the consequences under the INA for submitting that fraudulent information just wasn't relevant to the discretionary analysis. The upshot is that the Second Circuit sustained the removal orders against the DINs and the denial of their adjustment of status, but remanded on the narrow question of whether the Dhins had received proper notice of the consequences of filing a frivolous asylum application. And one extra thought for litigators challenging frivolousness findings in federal court. The government had actually argued that the Dhins' challenge to the frivolousness finding was moot, because even if they won on it, it wouldn't have affected the removal order entered against them. The Second Circuit, though, joining a number of other courts, rejected that argument because the frivolousness finding brings with it extra consequences, extra bars on immigration benefits that a removal order or even physical removal alone wouldn't. So it should always be possible to challenge a frivolousness finding in federal court, even if removability or denial of relief cannot be. And that was Dhin v. Garland.
Next up, Park v. Garland, published by the Ninth Circuit on June 29, 2023. This is a case about particularly serious crimes, withholding of removal, cat protection, and whether a foreign country's legal sanctions can be considered torture. It's a bit of a doozy, so let's strap in. Mr. Park was an LPR of the United States and a citizen of South Korea. In the span of 3 days, he was arrested in California twice, and he ultimately pled guilty to 13 charges, including possession of a controlled substance with a firearm under California Health and Safety Code Section 11370.1a as a result of the first arrest, and possession and transportation of cocaine for sale under California Health and Safety Code Sections 11351 and 11352a. He was then sentenced to concurrent 674-day terms and 5 years probation. In his removal proceedings, Mr. Park was charged as removable under INA Section 237 A2A III for having committed an aggravated felony, and INA Section 237 A2BI for having been convicted of a controlled substance law. He applied for cancellation of removal, asylum, withholding of removal, and cat protection. While Mr. Park admitted that he had never been harmed in South Korea, he asserted that he feared returning to South Korea for 2 main reasons. First, South Korea's, quote, extraterritorial jurisdiction law, end quote, allows South Korean citizens to be re-prosecuted in South Korea for drug crimes committed in the United States, and it imposes potentially extremely harsh punishment for those crimes, including life imprisonment, forced labor, or even the death penalty. And second, South Korea's military conscription policy requires males of a certain age range to serve in the military, where they could be subjected to harsh conditions, abuse, hazing, and rising suicide rates, and the only alternative to forced military service is forced labor for 3 years. As to Mr. Park's cancellation of removal and asylum claims, the IJ concluded that Mr. Park was ineligible for such relief due to his aggravated felony and drug trafficking convictions, and it doesn't look like Mr. Park contested that decision in his petition for review. As to Mr. Park's withholding of removal claim, the IJ concluded that based on, quote, the incident reports relating to Mr. Park's drug trafficking convictions, end quote, and the circumstances of Mr. Park's 2 arrests, Mr. Park had been convicted of particularly serious crimes, making him ineligible for withholding of removal. The BIA agreed, concluding that Mr. Park's second conviction for possession of cocaine for sale was a particularly serious crime. BIA also concluded that Mr. Park failed to overcome the matter of YL presumption because, quote, he had multiple arrests for possession of controlled substances, multiple types of controlled substances in his possession at both arrests, and a loaded firearm in his possession, end quote. In his petition for review, Mr. Park argued that the BIA improperly relied on his possession of a firearm in his first arrest, which was separate from his drug trafficking conviction resulting from his second arrest, and that the BIA failed to apply the matter of YL factors and erroneously substituted its own factors. Now, as I'm sure Kevin has covered on the pod many times, Attorney General Ashcroft's decision in matter of YL held that, quote, aggravated felonies involving unlawful trafficking in controlled substances presumptively constitute particularly serious crimes, end quote, except for in, quote, the most extenuating circumstances that are both extraordinary and compelling, end quote. And to get around matter of YL, a non-citizen must show that the conviction meets all 6 factors delineated in the decision, such that the conviction was a, quote, extraordinary, extenuating, and compelling case, end quote. In its 2007 decision, Miguel v. Gonzalez, the Ninth Circuit afforded Chevron deference to matter of YL and further held that the analysis of whether a particular offense can overcome the extraordinarily strong matter of YL presumption is an inherently discretionary decision. In Mr. Park's case, the Ninth Circuit further clarified that the 6-part test in matter of YL is just the minimum criteria that must be met to overcome matter of YL. But those 6 factors are not exhaustive. In other words, the Ninth Circuit clarified here that, quote, the agency may not consider non-listed factors that favor rebutting the presumption before it determines that the alien has satisfied the listed minimum criteria. But the same is not true if the agency identifies unlisted factors or circumstances that demonstrate the crime of conviction was serious and the presumption should apply, end quote. Therefore, quote, the agency does not abuse its discretion by concluding that this extraordinary and compelling standard is not met based on circumstances evidencing that the offense is particularly serious, even if those circumstances were not expressly listed by the Attorney General in defining the minimum showing that an alien must make to overcome the presumption, end quote. With all that being said, the Ninth Circuit rejected Mr. Park's argument and found that the BIA properly applied matter of YL's presumption and that the BIA's opinion was supported by adequate reasoning. According to the Ninth Circuit, the IJ invoked the matter of YL presumption and thoroughly recited the facts from Mr. Park's arrests, and the BIA affirmed the IJ's reasoning and added its own discussion of the presumption. And even though the BIA considered facts and evidence not specified by the Attorney General, such as the fact that Mr. Park had been arrested twice in 3 days for drug-related offenses, possessed a variety of drugs both times, and possessed firearms, this was not an abuse of discretion, because, according to the Ninth Circuit, quote, repeated conduct of the same or similar character is no doubt relevant in assessing the seriousness and risk of danger posed to the community by a petitioner's conduct, end quote. And so, Mr. Park's convictions were particularly serious crimes and made him ineligible for withholding of removal. But that still leaves his cat claim. As to that claim, the IJ concluded that Mr. Park failed to demonstrate that it was more likely than not that he would be tortured if removed to South Korea, either because of South Korea's extraterritorial jurisdiction law or its military conscription policy. The IJ essentially concluded that these were both neutrally applied laws and policies of South Korea, and that there was no evidence that either rose to the level of torture or that Mr. Park's fears were anything more than speculative. The BIA affirmed on all accounts, and in his petition for review, Mr. Park asserted 4 arguments challenging the BIA's decision, all of which, spoiler alert, the Ninth Circuit rejected. Mr. Park's first argument was that the BIA exceeded its regulatory authority by impermissibly engaging in predictive fact-finding. This argument stemmed from the fact that the IJ had erroneously stated that Mr. Park was not entitled to cat protection because he had not shown, quote, that any prosecution he might suffer would be based upon a protected ground, end quote. Mr. Park argued that the IJ's legal error necessarily resulted in erroneous factual findings, and that, as a result, the BIA's adoption of those factual findings, without first remanding to the IJ to apply the proper legal standard, was impermissible fact-finding. But the Ninth Circuit rejected this argument, because the BIA clearly corrected the IJ's error and clarified that, quote, an applicant for protection under the CAT need not show feared torture on account of a protected ground, end quote. And after making that correction, the BIA still concluded that Mr. Park failed to establish that it was more likely than not that he would be tortured, quote, regardless of the basis upon his removal to South Korea, end quote. As a result, the Ninth Circuit held that the IJ's legal error did not undermine its factual findings and was cured when the BIA applied the correct legal standard to the facts found by the IJ. Mr. Park's second argument was that the BIA failed to give a reasoned explanation for its decision. But this argument was based on Mr. Park's position that the Ninth Circuit could only review the BIA's decision and not the IJ's decision. But the Ninth Circuit disagreed and stated that it could review both decisions under the principle that when the BIA conducts de novo review, but the decision lacks, quote, any significant analysis, end quote, it suggests that the BIA gave, quote, significant weight to the IJ's findings, end quote, and allows the court to look to the IJ's decision, quote, as a guide to what lay behind the BIA's conclusion, end quote. According to the Ninth Circuit, this was such a case. Because of that, the Ninth Circuit reviewed both the BIA's and the IJ's decisions and found that, quote, when read alongside the IJ's multi-page CAT analysis, the BIA's decision adequately conveys the reasoning behind the denial of Park's CAT claim, end quote. Mr. Park's third argument was that the evidence did establish that he was more likely than not to be tortured by the South Korean government. But once again, the Ninth Circuit disagreed, relying heavily on 8 C.F.R. section 1208.18a3, which states that, quote, torture does not include pain or suffering arising only from, inherent in, or incidental to lawful sanctions, end quote, including, quote, judicially imposed sanctions and other enforcement actions authorized by law, including the death penalty, end quote. It also relied on its 2022 decision in Zampatzi Salazar v. Garland, discussed on episode 94 of the pod, that, quote, the record must show that it is more likely than not that the petitioner will face a particularized and non-speculative risk of torture, end quote. Regarding the risk of being re-prosecuted in South Korea for his drug convictions, the Ninth Circuit recognized that the regulation specifically, quote, does not give foreign countries unfettered discretion to avoid the CAT. Even so, the Ninth Circuit stated that, quote, a country's decision to prosecute certain crimes more aggressively or impose more severe punishments than the United States has chosen to impose does not necessarily establish torture, end quote. And not only did the Ninth Circuit find no evidence that South Korea's extraterritorial jurisdiction law was inherently torturous, it also found no evidence that Mr. Park would actually be re-prosecuted under the law, which, according to the Ninth Circuit, made Mr. Park's, quote, theory of torture based on his drug convictions a chain of speculative and unsubstantiated hypotheticals, end quote. And so the Ninth Circuit agreed with the BIA that Mr. Park failed to show that he would more likely than not be persecuted under South Korea's extraterritorial jurisdiction law. Regarding South Korea's military conscription policy, the Ninth Circuit reasoned that, quote, military conscription and punishment for evasion of military duty seldom constitute torture, end quote. The Ninth Circuit further stated that there was no evidence that South Korea's military conscription policy, which applies equally to all male citizens within the designated age range, is imposed, quote, with the intent of inflicting pain and suffering, end quote. And again, there was no evidence that Mr. Park would suffer a particularized risk of mistreatment in the military, especially considering that the record contained evidence that expatriates and dual citizens completed their military service unharmed. So long story short, the Ninth Circuit stated that while there is evidence of mistreatment within the South Korean military, it could not conclude that, quote, the approximately 600,000 people currently serving in the South Korean military are being subject to torture, or that Park would face a particularized risk of any level of mistreatment because he is an expatriate, end quote. Mr. Park's fourth and last argument was that the BIA erred by not aggregating his potential sources of torture. But yet again, the Ninth Circuit disagreed, recognizing that the BIA concluded that Mr. Park had not established that any of the mistreatment he fears, quote, regardless of the basis, end quote, rose to the level of torture. And after all that, the Ninth Circuit denied Mr. Park's petition for review. And that was Park v. Garland.
Next is Ramirez-Munoz v. Garland, issued by the Ninth Circuit on June 26th. This is a heady statutory interpretation case about false claims to U.S. citizenship. The case involves the inadmissibility ground at INA 212 A6C III, which renders inadmissible any non-citizen, quote, who falsely represents or has falsely represented himself or herself to be a citizen of the United States for any purpose or benefit under federal or state law, end quote. The sole question in this case is whether the inadmissibility provision applied to Mr. Ramirez. Most of the opinion is about unpacking the meaning of the word under. I told you it was a heady one. But first, let's discuss the facts. Mr. Ramirez was unlawfully present in the U.S. when he was twice arrested for driving under the influence. Both times, Mr. Ramirez lied and told the arresting officers that he was a U.S. citizen. He also admitted in removal proceedings that he had lied because he feared that if he told the police officers the truth, they would refer him to ICE and removal proceedings would be brought against him. Applying a precedential interpretation of the false claim to citizenship statute in matter of Richmond, the IJ and the BIA held that lying to avoid removal proceedings was a, quote, purpose or benefit under federal law, end quote. The Ninth Circuit disagreed. The Ninth Circuit statutory analysis is extremely minute and breaks down the statutory language a number of different ways. To simplify somewhat, the Ninth Circuit disagreed that it is enough that a false claim be made for a purpose or benefit governed by federal or state law. Because while laws can, quote, govern, end quote, who is entitled to what benefits, they can't govern a person's purposes. That, the Ninth Circuit said, would be akin to the thought police and would be unconstitutional. Instead, the Ninth Circuit held that under, as used in the false claim to citizenship statute, means in accordance with. So to trigger the inadmissibility provision, quote, the non-citizen must have made the false claim to citizenship to comport with some specific legal requirement, end quote. The Ninth Circuit offers a ton of legal analysis, digging pretty deep into the statute's grammatical structure, surveying statutory context, and even the legislative history. It's really a great example of the way detailed statutory analysis can win using the method that modern federal courts employ to interpret statutes. Anyway, under the Ninth Circuit's interpretation, lying to a state police officer about one's U.S. citizenship doesn't count. In reaching that holding, the Ninth Circuit joins the Third Circuit. The Ninth Circuit ultimately remanded back to the agency, quote, to either grant Ramirez's application for adjustment of status or explain, consistent with this opinion, why not, end quote. Congratulations to Marco A. Jimenez for the win. And before I go, one final thought. In rejecting deference for matter of Richmond's interpretation of the false claim to citizenship statute, the Ninth Circuit was careful to note that it was only finding fault with Richmond's interpretation of the word under. Matter of Richmond also includes a non-citizen friendly holding, namely that the false claim to citizenship must be material to the purpose or benefit sought. DHS had argued to the Ninth Circuit that it should reverse Richmond and hold that there is no materiality requirement, something that the 11th Circuit actually did in Patel. Liz and I wrote an article in the U Miami Law Review on why the plain language of the statute requires a materiality element. So if that issue ever comes up in a petition for review, check out the article. And with that shameless plug, that was Ramirez-Munoz v. Garland.
And that's it for this week. Now it's time for me and Ed to go. But Kevin will be back next week for your regularly scheduled episode. Until then, you're on your own, kids.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.